Welcome to The Explainer, where we break down complex topics. Today, we've got a fascinating legal puzzle with a twist that you will absolutely not see coming. So, what happens when something valuable just disappears from a locked bank vault? Today, we're diving into a real-life legal mystery that tackles that exact question. And if you happen to use a safe deposit box, what you learn today might just change how you think about it. Our story kicks off way back in 1979. It starts with a pretty standard land deal, but with a security measure that was supposed to make it foolproof. Okay, so here are the players. You've got a company, Agro Industrial, and they want to buy 2 pieces of land from the Pugal family. The deal was simple. The company pays in installments, and once the final payment is made, the Pugals hand over the official land titles. Straightforward stuff. But how do you make sure both sides are protected during the transaction? Well, their solution was to lock the land titles away in a bank's safety deposit box. The agreement was that the box could only be opened when both parties were present, and only after the company had paid in full. It really seemed like the perfect plan. So they went to Security Bank and rented a box. And the security setup was pretty clever. 2 separate renters' keys were made, one for the company and one for the Pugayos. But the bank also held a third key called the guard key. To open that box, you absolutely needed one of the renter's keys and the bank's guard key. Neither side could get in there alone. With those titles supposedly locked up tight and secure, the company saw a golden opportunity. They actually found a new buyer, which would have meant a very nice profit for them. A buyer, a Mrs. Margarita Ramos, offered to buy the lots, and for Agro Industrial, this resale was a massive deal. It would have netted them a profit that, at the time, was a very substantial amount of money. But of course, to finalize that new, profitable sale, they needed the titles. So on October 4th, 1979, everyone met at the bank. The company brought their key, the bank brought its guard key, they opened the box, and it was completely empty. The titles were just gone. Well, obviously, with no land titles to prove ownership, the deal with Mrs. Ramos just fell apart. That huge profit, it vanished into thin air. Feeling like they'd been wronged, Agro Industrial did what you'd expect. They sued the bank for damages. Okay, so let's get into the nitty-gritty, because the entire case, and whether the bank was responsible, all came down to one critical legal question. What kind of agreement are you really making when you rent a safety deposit box? Now, the bank pointed straight to the fine print in its rental contract. It said very clearly that the bank was not a depository and that it assumed absolutely no liability. You'd think that's case closed, right? Well, not so fast. This became the absolute heart of the legal fight. The bank argued it was a simple lease. Basically, they were just a landlord renting out a tiny metal room. But the company argued that it was a deposit because the bank's guard key meant they shared control and had a duty to protect what was inside. And legally speaking, the difference between being a landlord and a guardian is everything. The company's whole case was built on this idea of a contract of deposit. All that means is that it's a special agreement for safekeeping. If the court agreed, then the bank would be held to a much, much higher standard. It would mean they had an active duty to protect the items in the box. So after years and years of legal battles, the case finally made its way to the Supreme Court. And their final decision was going to set a huge precedent for every bank customer in the country. The court's logic was actually pretty simple. They said, look, the bank keeps a guard key. The renter cannot get into that box without the bank's help. That shared control means the bank has custody. And therefore, the contract isn't just a simple lease. It's a special kind of deposit. And here's the crucial takeaway from that decision. Because it's a deposit, the bank has a duty of care. And because of that, those clauses in the contract, the ones saying the bank had absolutely no liability, were declared void. You just can't put a clause in a contract that lets you off the hook for your own negligence. That's against public policy. So this sounds like a total win for the company, right? The court established it was a deposit, that the bank had a duty of care, and that the bank had failed. It seems totally obvious that the bank should have to pay for that lost profit. But in a really surprising and critical twist, the answer was no. The Supreme Court did not order the bank to pay for those lost profits. So why on earth didn't the bank have to pay? Well, this is where the court made a really key distinction. It said that even though the bank has a duty of care in principle, The company couldn't prove the bank was actually negligent in this specific case. Remember, two different parties held keys. There was no evidence at all to show the bank was the one at fault for the loss. They just couldn't prove how the titles disappeared. So, why are we talking about this decades-old case? Because it brilliantly illustrates a principle that is absolutely crucial for anyone who uses a safety deposit box today. So here's the bottom line. First, this case established that renting a safety deposit box is a special deposit relationship. Second, your bank has a legal duty of care, and they can't just get rid of that duty in the fine print. But third, and this is the most important part, if something goes missing, the burden of proving the bank was negligent falls squarely on you, the customer. And as this case shows, that can be incredibly difficult to do. And that leaves us with a pretty provocative thought to end on. This landmark case establishes a bank's responsibility, but it also shows just how hard it can be to actually enforce it. It leaves a lingering question of risk and trust, and who is truly responsible when your valuables vanish from behind a locked steel door.